Ever shared a video someone sent you? You might be breaking a serious law without even knowing it. So, could you actually go to jail?
Believe it or not, the answer is yes. Let's break this down. But really, it's all about protecting a person's dignity and honor in our digital world.
This is the core idea behind the law, respecting human rights. But what does it actually penalize?
It also includes sharing those recordings, and that's a super important point we're going to get back to.
And the law is super specific about what counts as a private area to protect people.
This is key. It's about when you believe you're private, even if you're in a public space.
So what actions are actually illegal? Well, the law outlines 4 main prohibited acts to watch out for.
So yeah, these 4 things form the backbone of the crime of digital voyeurism in the Philippines.
Okay, now here's the twist, and this is probably the most important part of the whole law.
Yeah, let that sink in for a second. The act of sharing it, that itself can be the crime.
And if you're caught, you're looking at some serious prison time, from 3 all the way to 7 years.
Plus, the fine can go as high as 500,000 pesos. That's a huge penalty. And it doesn't stop with just fines and jail time. It affects companies, public officials, and foreigners too. The law also has really specific rules about how these recordings can and definitely can't be used as evidence.
This law really makes you think, right? We're all accountable for the content we capture and especially share.
Welcome to The Explainer. Today, we're diving into a law that's all about protecting our private moments in a world that's always online. The Philippines Anti-Voyeurism Act. So to really get why this law is so important, let's start with a true story. And it's a pretty shocking one that actually went all the way to the Supreme Court. I want you to picture this. A family home, and inside that home, a bathroom. You know, it's pretty much the one place where you expect, no, you demand total privacy. It's supposed to be your safe space. Now, into this picture comes an uncle. He's a trusted family member, visiting his nieces often, supposedly just to help supervise some renovations. Nothing seems out of the ordinary at all. But then, things take a horrifying turn. One of the nieces, the court records call her AA to protect her identity, is getting ready for a bath when she spots something off. It's a soap box with a tiny drilled hole, and inside, a hidden phone with its camera pointing right out. And when she actually checks that phone, her worst fears came true. It was filled with multiple nude videos of her own sisters, and even her cousin, all secretly recorded in that very bathroom. You see, this was way more than just a terrible family betrayal. It was a straight-up crime, and the legal fight that followed would really put one of the country's most important privacy laws to the test. So in its 2023 ruling, the Supreme Court upheld the uncle's conviction, and they laid it out super clearly. The court said all 3 essential elements of voyeurism were there. 1. Was a private area recorded? Yes. 2. Was there consent? Absolutely not. And 3. Was there a reasonable expectation of privacy? Well, it was a bathroom, so that's a definite yes. Textbook case. So what exactly is this law that brought about justice in this case? Let's break down Republic Act number 9995, better known as the Anti-Voyeurism Act. It was passed way back in 2009, and its goal is crystal clear. It's all about valuing the dignity and privacy of every single person and making sure human rights are respected. It's literally designed to be a shield. And this law doesn't leave any room for confusion. It's super specific. Let's dig into the 4 main things that it says are absolutely illegal.
What's really amazing here is how thorough this is. See, it's not just about taking the photo or video without permission. That's illegal, of course. But so is copying it, selling it, or publishing it in any form, whether it's online, on TV, or anywhere else. Every single step in the chain is a crime. Okay, pay close attention to this, because this concept of separate consents is probably the most important part of the law for everyone to get. Even if someone says yes to being in a private photo or video, that is not the same as saying yes to sharing it. The law demands a second, completely separate and written permission to copy, sell, or broadcast it. Without that second consent, sharing is a crime. End of story. And make no mistake, this law has teeth. If you're found guilty of breaking it, the penalties are incredibly serious and absolutely life-altering. First off, there's prison time. We're talking a minimum of 3 years and up to 7 years behind bars. That is not a small thing. And that's not all. On top of jail, the court can impose a massive fine, anywhere from 100,000 pesos all the way up to 500,000 pesos.
And the punishments go even further depending on who the offender is. If you're a public official or a professional like a doctor or lawyer, you can face sanctions that affect your career. Foreigners get deported after serving their sentence. Even companies, like media outlets, can have their entire license to operate taken away.
So, where did a law this powerful come from? Well, it wasn't just created in a vacuum. It was actually born out of massive public outrage over a huge scandal that made it clear these protections were needed.
This timeline tells the whole story. It really kicked off with the Haliliko scandal in 2009. That's the case that really drove home the need for that separate consents rule. It led directly to this law being passed that same year. Then, fast forward to 2013, the Marjorie Barretto case showed the law's power against spreading private photos online. And all of that brings us to the 2023 Supreme Court ruling we started with, which just powerfully reaffirmed everything the law stands for.
Okay, so we've gone through the cases, the penalties, the fine print of the law. But what's the big takeaway? Why does all of this matter to you and me?
You know, it really all comes back to this one fundamental idea, written right into the law itself. It's about recognizing that every single person has an inherent dignity and a right to privacy. It's that simple and that profound.
Think about it. This isn't just about big court cases anymore. We live in a time where basically everyone has a high-definition camera in their pocket. This law draws a clear, non-negotiable line in the sand to protect our basic rights in this new reality. If you remember one thing from all of this, let it be this. In today's digital world, consent is not a suggestion. It's not just a nice thing to have. It is the law. It has to be explicit, it has to be informed, and sometimes it even needs to be in writing. It is not optional.
And that leaves all of us with a final thought. Taking a photo is one choice, but this law makes it very clear that the choice to share it carries an immense responsibility. A responsibility defined not just by what's right, but by what's legal. Thanks for watching.
Imagine, just for a moment, stepping into your bathroom. You walk in, you shut the door, you turn the lock.
Right. The one room where you're supposed to be completely safe.
Exactly. You turn on the faucet, wait for the water to warm up, maybe you glance in the mirror. It is, for all intents and purposes, your ultimate private sanctuary.
It's that absolute impenetrable barrier between you and the rest of the world.
Yeah, you exhale.
Yeah.
You are completely alone. But then, out of the corner of your eye, you notice something. Just a common household item.
Something so mundane, it practically just blends into the tiles.
Right. And you realize with this sudden just ice cold drop in your stomach that this innocent object is secretly watching you.
It completely shatters that fundamental illusion of safety we all rely on, just to exist in our daily lives.
It really does.
The idea that your private sanctuary isn't actually private at all. And it forces us to confront a really, really uncomfortable reality about the spaces we trust the most.
It is terrifying. And, well, it's the exact reality we are unpacking today. Welcome to the deep dive.
Glad to be here for this one.
So today we're looking at a landmark decision from the Philippine Supreme Court. It's GR Known 261049. It was decided in June 2023, but just released to the public in September 2024.
Fresh off the press, legally speaking.
Exactly. And alongside that ruling, we're digging into the complete text of Republic Act No. 9995.
Which is the Philippine Anti-Photo and Video Voyeurism Act of 2009.
Right. Plus, we'll look at the historical commentaries and the scandals that practically forced lawmakers to write that specific law. The mission for today's deep dive is clear. We want to explore what happens when the digital world violently invades our physical sanctuaries.
And how the legal system scrambles to draw a line in the sand when that happens.
Okay, let's unpack this. Because to understand the mechanics of the law, we really have to understand the human story that triggered it.
Yeah, because in an era where literally everyone has a high-definition camera in their pocket, understanding the legal boundaries of what constitutes privacy and consent, it's no longer just for lawyers.
No, it's essential everyday knowledge for you, the listener.
Yeah.
You have to know this stuff.
The definitions of these words are being tested and stretched every single day by the technology we interact with.
So true.
And this Supreme Court case gives us a perfect, albeit disturbing, lens to view exactly where the legal lines are drawn when those boundaries get violated.
So let's look at the anatomy of a startling discovery. According to the court documents, the date is October 11th, 2016.
Okay, setting the scene.
We are in a residential house in the Philippines, and it's undergoing renovations. Living in this house are 4 women.
And they're sisters and cousins, right?
Yes, and the court uses fictitious initials to protect their identities. So they are AAA, BVB, CCC, and DDD.
Makes sense.
Now, frequenting the house is their uncle, who the court calls XXX. He is there supervising the construction.
And there are 4 construction workers doing the physical labor there too.
Right, so that's the ecosystem. It's a busy household. People are coming and going. There's construction noise, dust everywhere.
It's a very normal, slightly chaotic family living situation.
Yeah, the kind of environment where you don't necessarily keep your guard up because, well, you're surrounded by family.
Exactly. You trust the people under that roof.
So we zoom in on the specific incident through the perspective of AAA. It's just a regular day. She goes into the kitchen to prepare hot water for her bath.
Standard morning routine.
While she's doing this, she sees her uncle, XXX, enter the bathroom. He stays in there for about 5 minutes, and then he comes out. Nothing seemingly out of the ordinary at all.
Just the normal choreography of sharing a house with one bathroom. You wait your turn. You don't think twice about it.
Right. So AAA gets her hot water and takes her turn. She goes into the bathroom, locks the door, and begins to prepare to bathe.
And sanctuary is locked.
But as she's getting ready, her attention is caught by something on a shelf. It's a Safeguard soap box.
Just a standard cardboard box of bar soap.
Yeah. But there is a tiny, almost imperceptible light shining through a small hole in that box.
Oh, wow.
Yeah.
The visual is just so incredibly specific. It's that artificial LED glow where there absolutely shouldn't be one.
All right, it doesn't belong there.
It's a detail that immediately signals something is wrong on a primal level. Your brain just flags it.
So she investigates. She looks inside the soap box, and she finds a BlackBerry cellular phone.
Inside the box.
Inside the box. And it's not just sitting there powered off. The video recording app is open. It is actively recording, and the timer shows it has been rolling for exactly 9 minutes.
And the court notes that the phone was placed inside the box in such a way that the camera lens was perfectly aligned with the hole.
Like a custom fit.
Exactly, capturing whatever was happening in the bathing area. It was a deliberate, calculated setup. It wasn't an accident.
It honestly reminds me of the concept of a Trojan horse, but like on a psychological level.
Oh, that's an interesting way to look at it. How so?
Well, the danger isn't just that the camera is hidden. It's that it's hiding inside an object you inherently trust or just completely ignore.
Right. A soapbox is synonymous with cleanliness and routine.
Exactly. By weaponizing something so mundane, the perpetrator bypasses the victim's natural security protocols. I mean, you don't scan a soapbox for threats.
No, of course not. And that subversion of the mundane is exactly what makes voyeurism so insidious. It turns the victim's own safe environment against them.
It's a total betrayal. And when AAA makes this discovery, the psychological impact is immediate and profound.
Because she recognizes the phone, doesn't she?
She does. She recognizes the BlackBerry immediately as belonging to her uncle, XX.
Her own uncle.
The court documents describe her as being scared but curious.
Yeah.
So she stops the recording and she checks the video.
Just to see what it actually captured.
Right. And she literally watches a video of him in the act of setting up the phone, positioning it inside the box, and aiming it at the shower area.
So she literally sees the trap being set by someone she has known her entire life.
Yes. And in a state of sheer, unadulterated panic, AAA deletes that specific video. She just erases it right then and there.
Wow. Okay, so she deletes it.
Yeah. Now, if I'm playing devil's advocate here, or if I'm a defense attorney, I'm looking at that action and I'm practically salivating.
Oh, absolutely.
The victim just destroyed the primary, undeniable piece of evidence linking the accused to the crime scene. How does the prosecution even survive that?
A defense lawyer would absolutely frame that as a catastrophic failure to preserve the chain of evidence. I mean, they would argue it introduces massive reasonable doubt.
Right, because the proof is gone.
Exactly. But what's fascinating here is how the Supreme Court handles this. They look at the reality of human psychology, invoking a concept known in law as a startling occurrence.
Okay, walk me through the mechanics of a startling occurrence.
Yeah.
How does the law justify the destruction of crucial evidence?
Well, the legal system recognizes that it cannot hold victims of sudden extreme trauma to the standards of, say, a trained forensic investigator.
Which makes sense. They're not cops.
Right. The Supreme Court cited a previous case, People v. Ampo, to explain this. When a human being is confronted with a frightful, traumatic experience like discovering your uncle is sexually predating on you in your own bathroom.
Your brain just short circuits.
Exactly. The amygdala effectively hijacks the brain. The fight, flight, or freeze response takes over completely.
So rational, forward-thinking logic just shuts down. You're not thinking about a future court date.
Completely. There is no standardized, legally mandated behavioral response to trauma. The court explicitly states that the workings of the human mind under extreme emotional stress are unpredictable.
Because everyone reacts differently.
Right. Some people freeze, some scream, and some take immediate action to eliminate the perceived threat. AAA saw her uncle's face looking through that lens, and her visceral physiological reaction was to obliterate that image.
She just wanted it gone.
Yes. And the court ruled that her action was a natural consequence of the startling occurrence. Therefore, her credibility as a witness was not destroyed by the deletion of that specific file.
That is a really crucial piece of legal empathy. It prevents the system from victim blaming someone for having a totally human reaction to a monstrous situation.
It really is. It grounds the law in human reality.
And remarkably, AAA actually manages to rein in that panic eventually. She realizes she needs proof, so she browses further through the contents of the BlackBerry.
And that's when the scope of the violation expands, right? From a single incident to a chronic pattern of abuse.
Yeah, it's horrifying. She finds several nude videos of herself, her sister BBB, her sister DDD, and her cousin CCC.
All of them.
All secretly filmed while taking a bath in that exact same area.
It's just a massive invasion.
So she quietly steps out of the bathroom, gets her own phone, sneaks back in, and uses her phone to capture snippets and still photos of the malicious videos playing on his screen.
Smart.
Then she puts the BlackBerry back into the soapbox, exactly how she found it.
Her presence of mind here is just astounding, especially right after a startling occurrence.
I know, it's incredible.
But there is a detail here that becomes the pivot point for the entire legal case later on.
Oh, right, the missing file.
Yeah. In her absolute terror and haste to gather evidence before her uncle returns to the bathroom, AAA misses getting a copy or a still photo of the video featuring DDD.
She just overlooked it in the rush.
Exactly. She secures the evidence for herself, for BBB, and for CCC, but she misses DDD's file entirely.
And that missing file is going to test the absolute limits of the law later on. But first, we have to look at the confrontation.
Because the aftermath of this discovery is where the defense strategy is born.
Right. So AAA locks herself in her room, waits for her aunt to get home, shows her the photos, and they essentially flee the house to call AAA's mother.
Getting to a safe distance.
Yeah. They rally the family, they gather the other victims, and together they confront the uncle.
The kitchen table confrontation. It's often the precursor to the courtroom battle. How did he react?
He denies it completely, but he builds a multi-layered defense. He basically has three main arguments.
Let's hear them.
First, he claims he didn't even own the phone. He stated he lost a similar BlackBerry 3 months prior.
Okay, that it wasn't me defense.
Second, he argues that there were 4 other construction workers in the house who had access and could have planted it.
Shifting the blame to the workers.
And third, he claims his nieces fabricated this elaborate story out of spite.
Over what?
Because he strictly reprimanded them for coming home late and not doing their household chores.
Wow. Okay.
Now, I want to push back on the way the court evaluates this, because if we look at those 3 defenses in a vacuum, they actually form a pretty standard cocktail of reasonable doubt.
Sure, on paper.
I mean, he's not the only man with physical access to the space. The smoking gun video of him setting it up was deleted by the victim. And family dynamics are famously messy people, really do lie out of spite.
They do. It happens.
So if you're a judge reading this transcript years later, how do you not just throw your hands up and say, I can't know for sure? How does a court choose who to believe?
It's the inherent difficulty of appellate law, right? The Supreme Court wasn't in the room. But this is exactly why the appellate courts place such massive weight on the findings of the regional trial court judge.
The trial judge.
Yes. The trial judge is the only person in the entire judicial hierarchy who actually sits in the room with the accuser and the accused. They observe what is legally called demeanor evidence.
Meaning they watch how a person behaves under the stress of actually testifying.
Exactly. A written transcript is flat. It captures the words, sure, but it doesn't capture the hesitation, the eye contact, or the physical breakdown of a witness during a brutal cross-examination.
You can't read a trembling voice on a page.
Right. When AAA was asked on the stand about seeing her uncle's face in that video, the trial judge witnessed her raw, unfiltered emotional reaction.
They saw the trauma firsthand.
And the appellate courts defer to the trial judge's assessment of who is telling the truth because the trial judge saw the humanity behind the testimony.
But what about his claim that they made it all up because they were mad about chores? False accusations do happen, unfortunately. How does the court legally dismantle that specific motive?
The Supreme Court dismantles it using an economic and social risk-reward calculus.
Okay, explain that.
When a defense claims witnesses are committing perjury out of, quote, ill motive, the court looks at the proportionality of the motive versus the cost of the lie.
The cost to the victims.
Right. The court highlighted the professions of these 4 women. AAA is a nurse, BBB is an accountant, DDD is a senior software engineer, and CCC is a content editor.
So they have established careers and professional reputations to protect.
Exactly. The court isn't making a moral judgment here about them being good people who would never tell a lie. They're making a logical calculation.
The math doesn't work out.
It doesn't. If these 4 women commit perjury to frame your uncle, they are risking years in prison themselves.
Right. Perjury is a serious crime.
And they are subjecting themselves to a grueling, public, and highly humiliating trial where the central topic of discussion is the existence of naked videos of their own bodies.
It's a massive self-inflicted wound.
They are permanently associating their professional names with a sordid sex scandal.
The ROI on that lie is catastrophically bad.
It defies human logic completely. The idea that 4 independent, self-sufficient professionals would willingly detonate a bomb in their own lives simply to enact petty revenge over being scolded about dishwashing, it's absurd.
Yeah, when you frame it like that, it's actually ridiculous.
The supposed motive does not match the staggering magnitude of the risk they were taking by coming forward. Therefore, the court rejected the spite defense as entirely implausible.
That makes perfect sense. It's not about inherent morality. It's about rational self-interest.
Exactly.
So with the defense's narrative falling apart, we need to examine the exact legal mechanism the prosecution used to secure a conviction. We need to decode Republic Act number 9995.
The Anti-Photo and Video Voyeurism Act of 2009.
Right. To really grasp how this law functions, we have to look at why it was drafted in the first place. Laws are usually reactive, right?
Right.
And this one was born out of a massive societal shock.
It was. The sources point heavily to the Halili Coast scandal around 2009.
What was the legal landscape like before that scandal hit?
Before RA 9995, the Philippine legal system was fundamentally unequipped to handle digital privacy violations. It just didn't have the tools.
Because the laws were written before smartphones.
Exactly. If someone recorded and distributed an intimate video of you without your consent back then, prosecutors had to try and shoehorn that act into antiquated laws.
Like trying to fit a square peg in a round hole.
They would try to charge perpetrators with things like grave coercion or general obscenity laws, or most commonly a charge called unjust vexation.
Okay, unjust vexation sounds like a fancy way of saying being a really annoying neighbor.
Honestly, that's practically what it is. It's a catch-all provision in the revised penal code for any human conduct that causes annoyance, irritation, or torment to an innocent person, but doesn't fit into a specific crime like physical assault.
So it's very minor.
Very. The penalty for unjust vexation at the time was incredibly light. Sometimes just a small fine or maybe a few days in jail.
So wait, if a disgruntled ex uploaded a highly intimate video to the internet, basically ruining a person's life and career, the worst the law could do was essentially give them a parking ticket for being annoying.
Precisely. It was a massive loophole. And the Halili Coast scandal exposed this vulnerability to the whole country.
Because that was a very public scandal.
Very public. It involved prominent figures, and intimate videos that were allegedly recorded with initial consent were then copied and distributed globally across the internet.
Which changed the whole dynamic.
The internet completely changed the mechanics of the crime. It wasn't just a peeping Tom looking through a bedroom window anymore.
Right.
It was the permanent, infinitely reproducible weaponization of a person's body. The legislature realized that unjust vexation was an absolute joke in the face of digital revenge porn.
They needed something stronger.
They needed a highly targeted law with severe teeth.
And that gives us RA 9995. So let's break down Section 4A, which is the core of our current case with the uncle.
Okay.
If I'm the prosecutor walking into court, what are the specific hurdles I have to clear? I'd assume the first hurdle is proving what was actually filmed. Because the law can't just say they filmed me naked, right? Naked can mean a lot of things.
Right. The law is surgically precise to avoid any ambiguity. The first element is that the accused must capture an image of the private area of a person.
How is that defined?
Section 3E defines private area strictly as the naked or undergarment-clad genitals, pubic area, buttocks, or any portion of the female breast.
Okay, so it's not just skin. A video of someone's bare back or their shoulders wouldn't trigger this specific law.
Correct.
But the inclusion of undergarment clad is really interesting to me.
It's vital. It means the law protects the intention of privacy, not just absolute nudity.
Oh, I see.
If someone points a camera up a skirt on an escalator, the fact that the victim is wearing underwear does not protect the perpetrator. The law recognizes that filming undergarments is still a profound violation of a private area.
That makes total sense. Okay, so you prove the private area was filmed. The second element is consent.
Which, in the case of a hidden camera inside a soapbox, is self-evidently absent.
Yeah, I mean, you can't consent to a recording apparatus you don't even know exists.
Exactly.
What is the third element?
The third element is the legal environment. The recording must happen under circumstances in which the person has a, quote, reasonable expectation of privacy.
How does the law define reasonable here? Because I could argue I have an expectation of privacy in my own backyard, but if my neighbor looks out their second-story window, they can clearly see me.
If we connect this to the bigger picture, the concept of a reasonable expectation of privacy is a cornerstone of modern jurisprudence. It's heavily influenced by global standards like the U.S. Supreme Court case Katz v. United States.
Oh, okay.
The Philippine law defines it as circumstances where a person believes they could disrobe in privacy without being concerned that an image of their private area was being captured.
So it's fundamentally about the belief in the security of the space.
Yes, and crucially, the law explicitly states this expectation applies regardless of whether the person is in a public or a private place.
Wait, that sounds like an oxymoron. How do you have a legal expectation of privacy in a public place?
Think about the architecture of public spaces. If you go to a shopping mall, you are in public. You have no expectation of privacy walking down the main concourse.
Right, anyone can see you.
But the moment you step into a fitting room, close the door, and slide the lock, the legal reality of that space transforms.
You're still in a public building,
But you have a subjective expectation of privacy. You believe you are alone, and society recognizes that expectation as objectively reasonable. A public restroom stall functions the exact same way.
you're carving out a temporary zone of absolute privacy within a public sphere.
Exactly.
And in the context of the uncle's case, a bathroom inside a private residential home is like the absolute fortress of that concept. When AAA locked that door, her expectation of privacy wasn't just reasonable, it was legally impenetrable.
Absolutely. The prosecution successfully proved all three elements for AAA, BBB, and CCC. Private areas were filmed, there was zero consent, and the expectation of privacy was absolute.
Which brings us to a really difficult pivot. We have the law, we have the mechanics, and we see how it worked to convict the uncle for 3 of the victims.
Right.
But the trial court, and eventually the Supreme Court, acquitted him for the crime against DDD, the senior software engineer. He was found not guilty on that specific charge.
And this is where it gets incredibly complicated.
I have to stop here, because this is where the strictness of the law feels just incredibly frustrating. We established the timeline, we established he owned the phone and hid it, and most importantly, AAA testified under oath that she physically saw a video of DDD naked on that phone before she put it back in the soapbox.
She was an eyewitness to the digital file.
Yes. Why is an eyewitness testimony delivered under the penalty of perjury not enough to secure a conviction for DDD?
It is incredibly frustrating from a moral standpoint, without a doubt, but it is a perfect illustration of the absolute bedrock of criminal law. The burden of proof.
Proof beyond a reasonable doubt.
Exactly. And to understand why DDD's case failed that standard, we have to look at the corpus delicti, the body of the crime, specifically for RA 9995.
Right, because voyeurism isn't like a physical assault, it's a crime of documentation.
Precisely. The essence of the crime under this specific law is the creation of a physical or digital file. If a person just spies on you through a keyhole, that is a massive violation, maybe unjust vexation or trespassing, but it is not a violation of the Anti-Photo and Video Voyeurism Act.
Because no media was captured.
Exactly. You have to prove the file exists.
Wow.
And because AAA, in her frantic rush, failed to copy DDD's video, the prosecution walked into court completely empty-handed for that specific charge.
They had nothing to show the judge.
They had AAA's testimony that she saw it, sure, but they did not have the digital file, a still photograph, or any tangible reproduction of the media itself.
But isn't eyewitness testimony enough in other crimes? I mean, if I see someone shoot a gun, the prosecutor doesn't necessarily need the video of the shooting if the jury believes my testimony, right?
True, but in a shooting, there is other physical evidence usually. A body, a bullet, gunpowder residue, a medical report. In a digital crime of creation, the digital file is the body.
Ah, I see.
The courts ruled that they cannot and will not convict a man to years in prison based on the assumption that a specific video existed, even if that assumption is highly, highly logical based on the surrounding facts.
It's a slippery slope.
It is. To allow a conviction for a digital media crime without the presentation of the media itself would set a terrifying precedent where anyone could be jailed for voyeurism purely on hearsay.
The law has to protect itself against false accusations, even if it means a guilty man escapes one of his charges. The strictness is the shield.
That's the reality of the justice system.
AAA's panic cost the prosecution that one conviction. But that brings us to the most fascinating legal maneuvering in this entire case.
The circumstantial evidence.
Yes, the prosecution lost DDD's case because they lacked the video. But remember, AAA deleted the smoking gun video of the uncle actually setting up the camera. They didn't have that video either.
Right, the setup video was gone.
So how did they secure the convictions for AAA, BBB, and CCC? They had the videos of the women, but how did they prove he took them?
Because for those three women, they utilized the doctrine of circumstantial evidence to prove who put the camera there.
You know, in pop culture, circumstantial evidence is almost always presented as a huge weakness. A TV lawyer will stand up and say, "Your Honor, this case is purely circumstantial, and the implication is that the case is about to completely fall apart."
I know, and that is one of the most pervasive myths in popular legal understanding.
Really?
Oh, absolutely. Direct evidence is, I saw him do it. Circumstantial evidence is, I saw him walk into the room with a knife, I heard a scream, and I saw him walk out covered in blood.
You didn't see the murder, but...
But the circumstances point to only one logical conclusion. The Supreme Court uses a really profound metaphor here to explain how powerful this can be. They state that circumstantial evidence is not a weak link in a chain. It is like a tapestry made up of interwoven strands.
I love that imagery. But explain the mechanics behind the metaphor. Why is a tapestry stronger than a chain?
If you build a prosecution like a chain, where fact A leads to fact B, which leads to fact C, well, if the defense manages to break fact B, the entire chain snaps. The case falls apart.
Right.
But a tapestry operates on mathematical probability. You weave dozens of individual strands of circumstantial evidence together. If the defense manages to pull one or two threads loose, the overall image in the tapestry remains completely visible and undeniable.
It still holds its shape.
Exactly. Rule 133, Section 4 of the Rules of Court dictates that circumstantial evidence is sufficient for conviction if there is more than one circumstance, the facts are proven, and the combination of all of them eliminates reasonable doubt.
It's the mathematical elimination of coincidence.
Yeah.
Let's look at how the prosecution wove this specific tapestry to trap the uncle. They couldn't show a video of him hiding the phone, so they built a net of circumstances.
There's by strand.
First strand, ownership. They didn't just prove it was a BlackBerry. They brought in witnesses who testified that he was the only person in the entire house who owned that specific model, and he was frequently seen using it.
Second strand, the mathematical timeline. The digital forensics on the phone were basic but irrefutable. When AAA found the phone, the timer said it had been recording for exactly 9 minutes.
Okay.
The prosecution worked backward. They subtracted the time AAA spent preparing her bath and the time she spent investigating the box. That math pointed precisely to the exact 5-minute window when the uncle was physically inside the bathroom.
The digital timestamp locked him into the physical space? That's incredible. Third strand, geographic exclusion.
The workers.
Right. The defense tried to blame the construction workers, but the prosecution wove in testimonies proving the workers were assigned exclusively to the second floor. They took their breaks outside, and they had absolutely zero access or reason to be in that specific first floor bathroom.
They systematically eliminated every other variable until only one remained.
And the final critical strand, the deleted video.
Even though the file was gone, the trial court accepted AAA's credible emotional testimony that she witnessed the video showing his face.
And that works as circumstantial evidence.
Yes. That testimony, while not enough to prove a separate crime on its own without the file, serves as a powerful thread in the larger tapestry of circumstantial evidence, proving he was the architect of the trap.
So what does this all mean for the listener? The takeaway is that the law doesn't require a Hollywood-style smoking gun or a recorded confession to catch a digital predator.
It rarely does in real life.
A meticulously established timeline, physical proximity, and the logical elimination of other suspects create a mathematical probability of guilt that the courts completely recognize as proof beyond a reasonable doubt.
Exactly. The tapestry holds, and with the trial mechanics resolved, we really need to look at the broader implications of this law.
Let's do it.
Because capturing the image is only the genesis of the crime. The sources emphasize that RA 9995 was designed to address what happens after the recording stops.
Because the real terror of modern voyeurism isn't just that someone looked at you in a private moment, it's the sheer panic of who else they might show it to.
The internet makes the violation infinite.
How does the law address the distribution of these images?
RA 9995 utilizes what we can conceptualize as a two-tier consent rule. It recognizes that consent is not a blanket permission slip. It is highly specific to the action.
Break down the two tiers for us. Let's move away from the uncle's case, which was completely non-consensual, and look at a hypothetical scenario to understand the nuance.
Okay, imagine a couple in a consensual relationship. They decide, mutually and enthusiastically, to film themselves in an intimate moment. They both agree to the recording.
Okay, so Tier 1 consent is met. The creation of that video is 100% legal under the law.
Right, but that consent has a hard boundary.
Okay, what's Tier 2?
Tier 2 is the boundary of distribution. The law explicitly states that even if you enthusiastically consented to being recorded, the other person cannot share, distribute, broadcast, or even copy that video to a third party without your separate, specific, written consent.
Wait, written consent, not just a verbal, yeah, you can send that to your phone?
It has to be explicit. The consent to make the media is legally distinct from the consent to share the media.
Why?
This is the legal bulwark against revenge porn. If a relationship ends bitterly and one partner decides to upload that originally consensual video to social media out of spite, they're committing a severe crime under RA 9995.
So the initial consent to film means nothing if you didn't consent to upload it.
Exactly. The fact that the victim smiled at the camera when it was filmed is entirely irrelevant to the crime of unauthorized distribution.
The sources mention the Marjorie Barreto case from 2013 as a massive cultural touchstone for this exact concept.
It was a watershed moment in the Philippines. Marjorie Barreto, a prominent former actress, had private, highly intimate photos circulated online without her authorization.
And she fought back.
Vigorously. Her legal team used RA 9995 to file charges against the individuals responsible for the spread. Because of her high profile, the case served as a nationwide public education campaign.
It showed everyone how the law worked.
It demonstrated to the public that the unauthorized circulation of intimate images is a heavily penalized criminal act, completely separate from how the photos were originally sourced.
It fundamentally shifted the blame from the person in the photo to the person pressing send.
Exactly.
And speaking of legal bulwarks, there is a fascinating protective measure built right into the text of RA 9995 to prevent these images from being weaponized within the legal system itself. It's Section 7. Inadmissibility of evidence.
Oh, this is a brilliant piece of legislative foresight. It essentially creates a fruit of the poisonous tree doctrine specifically for voyeurism.
How does Section 7 work?
It states that any photo, video, or recording obtained in violation of this act is strictly inadmissible as evidence in any judicial, quasi-judicial, legislative, or administrative hearing.
Why is that necessary? Give me a scenario where someone would actually try to use illegal voyeurism footage in a court.
Okay, imagine a brutal, highly contested child custody battle. One spouse hires a private investigator to illegally plant cameras in the other spouse's home, hoping to catch them in a compromising position or an intimate encounter to prove they are an, quote, unfit parent.
Wow.
They capture the illicit video and try to introduce it into the family court record to destroy the victim's character.
So they use a crime to win a civil case.
Section 7 stops that completely. It dictates that the judge cannot even look at it. It is struck from the record immediately. It prevents the legal system from becoming a secondary tool of victimization.
That's amazing. Are there any exceptions?
The only exception is if a peace officer secures a highly specific written court order because they need to use the video to prosecute the voyeurism crime itself.
Right, to prove the actual crime.
But for any other purpose, blackmail, character assassination, and civil court corporate disputes, the media is legally radioactive. You cannot use it.
That is incredibly reassuring. Now, voyeurism doesn't exist in a legal vacuum. The sources point out that when someone commits this crime today, they rarely just violate RA 9995. They usually trip over a cascade of intersecting modern laws.
The legal jeopardy multiplies rapidly today. If you capture an illicit video, you violate the Anti-Voyeurism Act, obviously. But simply by possessing and digitally processing an image of a person's body, you are handling deeply personal data without consent.
Which triggers another law.
Yes, that can trigger the Data Privacy Act of 2012.
And what if you distribute it online? like post it to a forum.
Then you cross into the devastating territory of the Cybercrime Prevention Act of 2012.
And cybercrime laws are notoriously harsh.
The cybercrime law acts as a massive penalty multiplier. Under Philippine law, if a crime defined by the revised penal code or a special law like RA 9995 is committed using information and communication technologies, the penalty is generally increased by 1 full degree.
So the internet makes the punishment worse.
The internet isn't just a medium. The law views it as an aggravating circumstance because it makes the damage permanent and global.
Which brings us perfectly to the tangible consequences of this specific case. We need to look at the price of privacy. What penalties and damages were actually handed down by the Supreme Court to the uncle for shattering the sanctuary of his nieces?
The state did not show any leniency here.
Yeah.
For the 3 convictions, the cases of AAA, BDB, and CCC, the uncle was not given a single blended sentence. He was sentenced consecutively for each distinct violation.
Let's break down the timeline of that sentence.
For each of the 3 cases, he faces an indeterminate penalty of roughly 4 years and 6 months as a minimum, up to 6 years and 10 months in prison as a maximum.
I want to pause on that term, indeterminate penalty. Why doesn't the judge just say you are sentenced to 5 years? How does the indeterminate sentence law function here?
The indeterminate sentence law is designed to incentivize rehabilitation. Instead of a flat number, the court provides a range, a minimum, and a maximum.
How does the range work in practice?
The convict must serve the absolute minimum time behind bars. Once they hit that minimum, in this case 4.5 years per charge, they become eligible for parole, provided they have shown good behavior and rehabilitation.
And if they haven't?
If they are denied parole, they can be held all the way up to the maximum of nearly 7 years.
And because he has 3 convictions, you stack those ranges, he is looking at a massive chunk of his life in a penitentiary. And there's a financial component as well, right?
A severe one. He was ordered to pay a criminal fine of PHP 300,000 for each of the 3 cases.
Wow.
That totals nearly 1 million pesos in pure criminal fines payable directly to the state.
But the punishment doesn't stop at state fines. The victims themselves are entitled to civil damages.
Yes. The Supreme Court anchors this right in Article 26 of the Civil Code, which is a beautiful piece of legislation.
What does Article 26 say?
It explicitly commands every person to respect the dignity, personality, privacy, and peace of mind of their neighbors and family. Violating that peace produces a legal cause of action for damages.
And voyeurism definitely violates that peace.
Absolutely. The courts recognize that the uncle's perverse, predatory actions caused the victims profound distress, humiliation, and mental anguish. Therefore, they are entitled to moral and exemplary damages.
Let's define those terms, because they serve different purposes. What is the difference between moral and exemplary damages?
Moral damages are compensatory. They are awarded to alleviate the psychological pain, the sleepless nights, the trauma, and the sheer mental anguish caused by the crime.
You're trying to put a price tag on pain.
You can't put a perfect price tag on trauma, but the court tries to provide financial solace. Exemplary damages, on the other hand, are punitive.
Like a punishment fine.
Right. They're an additional fine levied against the perpetrator specifically to set a public example to deter the public from committing similar atrocious acts.
But this brings up a really confusing element in the Supreme Court's final ruling. The regional trial court initially awarded each victim PHP 50,000 in moral damages and PHP 30,000 in exemplary damages.
Yes, the initial ruling.
But when it got to the Supreme Court, the highest court actually reduced those amounts. They dropped it down to PHP 15,000 for moral and PHP 15,000 for exemplary damages per victim.
It's a significant drop.
Why on earth would the Supreme Court reduce the payout to victims of such a heinous violation?
This raises an important question, and it feels incredibly counterintuitive, almost like a slap in the face to the victims. But it is rooted in how the Philippine legal system rigidly scales damages to maintain algorithmic consistency across all types of crimes.
Algorithmic consistency.
Yeah. The Supreme Court is bound by prevailing jurisprudence, and they specifically cited cases like People v. Jugueta and Carbonell v. People.
How does Jugueta dictate the value of trauma?
Jugueta established a strict hierarchy of damages based on the ultimate severity and physical outcome of the crime. For example, under that precedent, moral damages of PHP 50,000 to PHP 100,000 are standard for crimes that result in the actual death of the victim, like murder or homicide.
So damage to scale with the physical violence?
Exactly. The Supreme Court, while explicitly stating they are not trivializing the severe psychological trauma of voyeurism, had to legally acknowledge that this specific offense did not result in death or physical bodily injury.
So it's a cold systemic calculation.
Yeah.
To keep the entire legal system balanced, they had to align the financial damages with similar non-fatal, non-physical injury precedents.
Exactly. PHP 15,000 aligns with the established precedent set for crimes like acts of lasciviousness. It's the cold logic of maintaining a predictable judicial system.
Even if it feels unfair to the victims.
Yes. And furthermore, the Supreme Court made another incredibly strict procedural correction. They deleted the award for the victim's attorney's fees entirely.
Why? I mean, these women had to hire lawyers to prosecute their uncle. They incurred massive expenses to get justice. Why wouldn't the court force him to pay for that?
Under Article 2208 of the Civil Code, forcing the losing party to pay attorney's fees is considered the exception, not the general rule.
Oh, I didn't realize that.
The Supreme Court noted that both the Regional Trial Court and the Court of Appeals completely failed to discuss why attorney's fees were justified in the actual written text of their decisions.
They just added it at the end.
They just tacked it onto the final ruling in the dispositive portion without any written rationale in the body of the text.
So it was basically a clerical error by the lower judges.
Essentially, yes. The Supreme Court is ruthlessly strict about this procedure. The factual or legal justification for awarding attorney's fees must be explicitly stated and argued in the body of the decision.
And because they skipped that?
Because the lower court judges skipped that procedural step and failed to explain their reasoning in writing, the Supreme Court disallowed the fees on appeal.
That is a harsh, expensive lesson in procedural precision.
It is, and unfortunately, the victims bear the financial brunt of that judicial error.
Wow. So we have explored the entire life cycle of a modern privacy invasion. We started with the horrifying reality of a digital peeping Tom violating the sanctuary of a bathroom.
We unpacked the psychological reality of the startling occurrence and how the mind reacts to trauma.
We decoded the strict, precise requirements of RA 9995 and the 2 tiers of consent. We saw how the mathematical probability of circumstantial evidence can weave an inescapable tapestry.
And we've witnessed the state's complex, sometimes coldly logical dedication to punishing these crimes while maintaining legal consistency.
We've traced the journey of a single flashing LED light in a soapbox all the way up through the appellate courts to the highest tribunal in the land.
It's been a massive journey.
And to you, the listener, this deep dive is a reminder that the legal framework exists and is actively evolving to protect you. The boundaries of your consent are absolute, whether you are in your own home or a public space.
The law recognizes that the technology surrounding us can be weaponized, and it has built mechanisms like RA 99995 to catch up with that threat.
But as we close this analysis, I want to leave you with a final thought to mull over, building purely on the facts we've discussed today. In this case from 2016, a simple safeguard soapbox was manipulated to shatter the reasonable expectation of privacy.
It took a physical cardboard box and a bulky physical BlackBerry phone to execute the crime.
But consider the trajectory of technology over the last decade. The hardware is practically vanishing.
Precisely. Cameras are continuing to shrink at an exponential rate. They are no longer the size of a phone, they are the size of a pinhead.
They don't need to be hidden in a soapbox with a hole cut in it anymore.
No, they are disappearing entirely into the fabric of everyday objects, built directly into the casing of alarm clocks, smoke detectors, charging blocks, and air purifiers.
They're becoming native to the environment. They just look like part of the house.
So the question we have to ask ourselves as we look toward the future of privacy law is this. As these recording devices become truly undetectable, seamlessly integrated into the background of our lives, how will the legal definition of a reasonable expectation of privacy hold up? It's a terrifying thought. If a judge determines that a soapbox isn't safe, what happens when the walls, the appliances, and the very architecture of our homes become potential observers?
What will it take for the courts to completely redefine what it means to be truly alone?
Exactly.
It's a chilling thought to take with you the next time you step into your sanctuary and lock the door.
Thank you for joining us on this deep dive. Stay curious, stay aware, and above all, stay well informed.
Welcome to the debate. Imagine holding the smartphone of the person who just, profoundly violated your privacy. In a blind panic, your thumb hovers over the screen and you delete the very video, the only video really, showing their face setting up the camera. Did you just destroy the case? did you just let them get away with it?
It is a terrifying scenario because in that split second, human instinct completely collides with the cold, strict demands of the criminal justice system.
Right.
I mean, we demand absolute proof to put someone in prison, but human beings rarely behave perfectly in the middle of a nightmare.
Absolutely. And today, we are looking at a recent Philippine Supreme Court decision, specifically GR 261049. It tests the absolute boundaries of their Anti-Photo and Video Voyeurism Act, which is also known as Republic Act 9995.
Yeah, it's a fascinating case.
It really is. The central question we are unpacking is a profound one. Can an interwoven tapestry of purely circumstantial evidence legally and, well, logically, overcome the intentional deletion of the only direct evidence linking a perpetrator to a crime?
And it's really a question of where the burden of proof truly lies. I will be arguing that when a victim permanently destroys the sole piece of identifying digital evidence, while selectively preserving other evidence, it creates an inherent reasonable doubt.
Which is a strong stance.
Well, in our justice system, circumstantial facts simply cannot fill a void created by the intentional destruction of direct evidence.
And I will be arguing that a robust chain of circumstantial evidence, when combined with a realistic understanding of unpredictable trauma responses, perfectly satisfies the burden of moral certainty required for a conviction.
Okay, so to really get into the mechanics of this, we have to look at the factual foundation the trial court and ultimately the Supreme Court relied upon.
Right. Let's look at how the court arrived at this conviction, because the physical and temporal realities are just striking. So the accused is the uncle of the victims. He was proven to be the only person in that household who owned the specific device used to film them.
Which was a BlackBerry phone, right?
Exactly, a BlackBerry. The timeline is incredibly tight here. He was seen using the second-floor bathroom for 5 minutes immediately before one of the victims, whom the court refers to as AAA, entered.
Okay.
Upon entering, she found that specific BlackBerry hidden inside a safeguard soap box. The camera was perfectly positioned to capture the shower area, and here's the kicker. The recording had already been running for 9 minutes.
The proximity is undeniable, I'll give you that. You have a 5-minute bathroom use nested right up against a 9-minute running recording. But we have to pause right there.
Why?
Because what AAA did next is the crux of this entire dispute. When she played the video back, she saw her uncle's face setting up the camera, and then she deleted it.
She did. Out of shock. I mean, pure shock.
But she didn't just drop the phone in shock. This is where we get into the selective preservation of evidence.
Right.
After deleting the only video that directly showed the perpetrator's face, she simultaneously possessed the presence of mind to leave the bathroom, retrieve her own phone, return to the scene, and meticulously capture snippets and stills of the other nude videos of herself, her sisters, and her cousin.
It's a lot. Yeah.
And then she returned the BlackBerry to the exact position in the soapbox.
Which, sounds methodical when you list it out like that. I admit, I struggle with that part too. Because on paper, it looks calculated.
Very calculated. But I think we have to look at how circumstantial evidence actually operates in the justice system before we dissect her psychology. The Supreme Court utilizes a powerful analogy here, describing circumstantial evidence as an interwoven tapestry.
Okay.
Rule 133, Section 4 of the Rules of Court lays out the mechanics of this. Essentially says that courts don't pluck out one strand of evidence and analyze it in a vacuum. They look at the pattern.
I come at it from a different way. The problem with the tapestry analogy is that in any structure, some strands are load-bearing.
Load-bearing? Yeah. If you remove the central thread that ties the device directly to the man's hands in that specific moment, the video of his face, the entire structure sags. You are talking about the mechanics of circumstantial evidence, but the fundamental mechanism relies on excluding all other possibilities. And here, there is a gaping hole.
Is it a gaping hole, though? Look at the sheer improbability of anyone else committing this act.
Wow.
You have a timeline perfectly aligning with his bathroom use, and the fact that the 4 construction workers present in the house did not have access to that specific floor. It leaves no other logical perpetrator. The law asks for moral certainty, not mathematical perfection.
Right, but
How do we reach moral certainty? By looking at the absurdity of the alternatives.
let's unpack the alternatives then, because I think the court dismissed them too quickly based on the weakness of the defense. The uncle claimed he lost his phone 3 months prior. He also claimed his nieces fabricated this elaborate story because he scolded them for coming home late and avoiding chores.
Which defies all common sense. Look at the profiles of these victims established on the material. These are professional women. We're talking about a nurse, an accountant, a senior software engineer, and a content editor.
I know, but
The psychological reality that 4 professional women would subject themselves to the excruciating public humiliation of a voyeurism trial, literally having their most private violating moments entered into public record, just to get back at an uncle over washing dishes, is frankly absurd.
I concede that his defense is incredibly weak. It borders on the nonsensical, really. But the burden of proof lies entirely with the prosecution, not the defense. A weak defense does not automatically elevate circumstantial evidence to the level of beyond a reasonable doubt.
Okay, but the circumstances are so tight.
You mentioned the 4 construction workers earlier. The prosecution relies solely on the victim's verbal assurance that these laborers had no access to the second-floor bathroom. Think about how a house under active renovation operates.
Sure, it's chaotic.
Exactly. Relying on a simple verbal claim that workers absolutely could not have walked up a flight of stairs is an incredibly fragile thread to hold your entire tapestry together.
But again, probability. What is the probability that a random construction worker found the uncle's lost phone, snuck upstairs exactly when the uncle finished using the bathroom, set up the camera, and snuck up back down without being seen? The courts weigh these probabilities.
They do, but they're weighing them without the physical evidence. The actual BlackBerry phone was never confiscated by the victims or the police.
They were traumatized.
The victims admitted they didn't secure it, so without the physical device to check digital fingerprints, timestamps, metadata, or device registration, and without the video of his face, the court is convicting purely on proximity and assumption.
I see why you think that, but let me give you a different perspective on the human element here. You are demanding a level of perfect logical consistency from a victim of a severe privacy violation that simply doesn't exist in the real world.
I'm just demanding evidence.
Digital voyeurism is a profound sexual violation. Expecting a victim to act like a seasoned forensic investigator in the immediate moment of discovery is unreasonable.
I don't expect a forensic investigator. I expect the evidence to match the claim of blind panic.
But panic isn't a monolith. Think about the duality of trauma. It's like a driver in a horrific car crash who somehow has the presence of mind to turn off the ignition and grab their insurance card from the glove box, but then walks 3 miles in the wrong direction down the highway because they are in clinical shock.
Wow, okay.
Executive function and blind panic can share the exact same space in the human brain. The Supreme Court rightly noted that there is no hard and fast gauge to measure behavior when confronted with a horrifying occurrence.
That's a compelling argument, but have you considered the incredibly specific nature of her executive function in this scenario? I hear your car crash analogy, and I agree, trauma isn't logical. But if that driver in the crash didn't just grab their insurance, but also meticulously wipe down the steering wheel before walking away, we would ask questions.
Wiping down the steering wheel implies a cover-up. AA deleting the video was an act of revulsion.
But she
saw a tiny light in a soapbox. She looked inside and saw a phone recording her naked, and the very first thing she saw on playback was the face of her own uncle setting it up. The betrayal is absolute. Deleting that specific video was a reflex of pure horror. She was literally trying to erase the traumatic reality she was just confronted with.
I understand the revulsion. I really do. But let's look at the immediate sequence of events that followed. After this moment of pure, blinding horror that caused her to delete the footage of his face, she stepped out of the bathroom. She retrieved her own phone.
Yes.
She returned to the bathroom. She browsed through the uncle's phone to find the other videos of her sisters and cousin. She played them, captured snippets, took still photographs of those videos using her phone, and then placed the BlackBerry back inside the safeguard soapbox in the exact position she found it.
Which shows a profound protective instinct. Her brain oscillates from, I cannot look at the man who betrayed me, to I have to protect my sisters.
But if she had the cognitive clarity and emotional control to stage a covert, multi-step evidence-gathering operation, putting the phone back perfectly so the uncle remained unaware, the permanent deletion of the singular smoking gun video cannot simply be written off as blind panic.
It wasn't just panic, it was horror.
It creates an evidentiary void. By destroying that video, she essentially rendered her own testimony about what that video contained completely immune to forensic scrutiny. The defense cannot independently verify or challenge evidence that the accuser intentionally destroyed.
I want to push back on the idea of an evidentiary void, because we are not just prosecuting the act of setting up the camera. We are prosecuting the reality of what was captured. We have to look at the specific legal parameters of Section 4A of Republic Act 9995. The elements of the crime are strictly met here.
Let's review how those elements are defined then, because the law is very specific about the medium.
Right. So the law defines the prohibited act as capturing an image of the private area of a person naked or undergarment-clad genitals, pubic area, buttocks, or female breast, without consent, under circumstances where there is a reasonable expectation of privacy.
Which a bathroom obviously is.
Exactly. A private bathroom inside a family home is the quintessential environment for a reasonable expectation of privacy. The sheer fact that these images existed on that device and were captured discreetly without consent proves the actus reus, which in legal terms is just the physical act of the crime itself.
Sure.
The law is fundamentally designed to protect human dignity and peace of mind. The court awarded moral and exemplary damages of PHP 15,000 each per victim precisely to validate the severe mental anguish caused by this exact breach. The acts happened.
I'm sorry, but I just don't buy that. Let me tell you why. I completely concede that the crime undeniably occurred. The elements of voyeurism under RA 9995 are met. Someone placed a camera in that bathroom. Someone utterly violated these women's dignity.
Absolutely.
But a criminal trial doesn't just ask if a crime happened. It asks who committed it, and it demands the answer beyond a reasonable doubt.
And the interwoven tapestry of timing, ownership, and lack of alternative motive points strictly to him.
But look at the precedent this sets for the mechanism of justice in the digital age. Digital evidence is fundamentally different from physical evidence. It is perfectly reproducible, but it is also notoriously easy to manipulate, edit, or misinterpret.
That's a broad generalization, though.
The statute itself, in Section 7, is incredibly strict about the inadmissibility of evidence obtained in violation of the Act. The law treats this kind of media with extreme caution. Yet here, we are allowing a conviction based on a curated subset of digital files.
Oh, curated way to sound malicious. She preserved what she could stomach preserving.
Intentional or not, it is curation. And without the original physical device, we are trusting one person's uncorroborated curation of digital evidence to send a man to prison. The defense never had the opportunity to examine the original device.
Because the uncle claimed he lost it.
Forensic analysis to see if the video of his face actually ever existed, or when it was truly filmed, or if the metadata matched the time frame the prosecution claimed.
But there was no allegation of digital forgery by the defense during the trial. He didn't say, she faked the timestamps. He just stubbornly repeated that he lost the phone months ago.
Because what else could he say? When the physical device is missing and the primary digital evidence is destroyed, the defense is stripped of its ability to investigate. When we allow a conviction based on photos taken of a screen from a device that the victims failed to confiscate, we open the door to terrifying possibilities in future cases.
Such as?
What happens when someone maliciously plants a device, curates the footage to remove themselves, and blames the owner of the phone? The standard of beyond a reasonable doubt exists precisely to prevent that mechanism of framing.
You are arguing a slippery slope that ignores the totality of the circumstances specific to this case. The justice system does not operate in a vacuum of hypothetical digital manipulation. It operates on the proven, breathing facts of the case at hand.
The facts that we have.
Yes, and you keep circling back to the evidentiary void. But the trial court, which had the unique opportunity to observe the demeanor of the witnesses, found AA's testimony regarding her shock and her subsequent actions to be highly credible.
Demeanor isn't proof.
There is a reason the Supreme Court consistently defers to trial courts on witness credibility.
The trial judge sees the emotion, the candor, the hesitation, and the truthfulness firsthand. You can't capture that in a transcript.
I respect the trial court's role in assessing human behavior. I do. But appellate review and the Supreme Court's role exist to ensure the cold hard math of the evidence adds up to moral certainty.
And I maintain that it does. Let's summarize the prosecution's math here because it is overwhelming. We have the exclusive ownership of the specific BlackBerry model by the accused. We have his physical presence at the house. We have the exact timing, his 5-minute use of the bathroom immediately preceding the discovery of a device that had been rolling for 9 minutes.
Again, circumstantial.
And we have the unquestionable lack of credible ill motive from 4 professional women who had absolutely nothing to gain and everything to lose by coming forward.
But you are still substituting high probability for absolute certainty.
Because absolute certainty in the wake of trauma is a myth. To demand perfect digital preservation from traumatized victims in this context would render the Anti-Photo and Video Voyeurism Act completely toothless. Think about the philosophy behind the law. If a voyeur can escape justice simply because a traumatized victim dropped the phone or deleted a file in a momentary reflex of panic, the law completely fails to protect the very dignity it was enacted to preserve.
Whoa.
The unbroken chain of circumstantial evidence here is a legitimate, legally sound pathway to moral certainty.
While I deeply sympathize with the victims, and I fully acknowledge they suffered a profound and undeniable violation of their privacy, the standard for criminal conviction simply cannot be compromised, regardless of the emotional weight of the offense. The intentional deletion of the most critical piece of direct evidence, the only video showing the perpetrator's face, coupled with the complete failure to confiscate the physical device, introduces a reasonable doubt that circumstantial assumptions cannot cure.
Even with the perfect timing and the utter lack of alternative suspects?
Yes, because the burden is on the state to prove guilt, not on the accused to prove his innocence. By allowing a conviction based on a selectively preserved digital record where the identifying evidence was permanently destroyed by the accuser, we erode the foundational protections of the accused. We are essentially replacing the standard of beyond reasonable doubt with highly likely given the circumstances.
I think that's a bit reductive.
That standard might be entirely sufficient for a civil suit for damages, but it should never be sufficient to deprive a person of their liberty for up to 7 years.
Well, it is clear we are looking at 2 fundamental pillars of justice that are seemingly in conflict here. GR number 261049 serves as a truly fascinating lens into the complexities of modern law. It perfectly illustrates the difficult intersection between strictly written digital privacy legislation, the entirely unpredictable nature of human psychology during a crisis, and the ancient, unyielding standards of criminal justice.
It really does. It highlights this incredible philosophical irony. I mean, we live in a digital age where technology captures everything perfectly, yet the human beings handling that technology are as flawed and unpredictable as ever. The source material offers even more layers, particularly regarding how courts handle the inadmissibility of such digital evidence in other contexts under Section 7 of the law.
Definitely.
It forces us to ask how the justice system should adapt to technologies that are simultaneously ubiquitous and incredibly fragile. I highly invite our listeners to read the full decision and explore those nuances for themselves.
There is definitely more to explore there, and it's a perfect opportunity for the listener to dig into the text and form their own conclusion. Which brings us back to where we started. When you step into a courtroom to evaluate human trauma and digital footprints, you are not looking at a clean, perfectly illuminated X-ray of a broken bone. You are looking at a messy, fragmented picture, and society, through its courts, has to decide just how clear that image needs to be before we render a judgment. Thank you for joining us.